So welcome everybody. This is the Civics Project and I'm Beth Ribet, the Director of Repair and the host of the Civics Project. We'd like to begin today's session with a land acknowledgement. Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands. And we're grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohimkem, our relatives and relations, past, present, and emerging. So today's subject focuses on campaign finance, which is also sometimes referred to as election finance or just by the popular term political donations. Campaign finance refers to funds for policy initiatives, to funding for political parties, and also funding for individual candidates for office, and that can be a federal, state, or municipal office. At the U.S. federal level, the primary entity that's responsible for monitoring, enforcing rules and regulations, and generally managing the elections process is the FEC, also known as the Federal Elections Commission. Authority over state elections is maintained under state law, and the process by which that's done can vary from state to state. Many states will have a registrar of voters, others will have different entities that are taking responsibility. State legislatures are often involved, so are state courts. And similarly, at the municipal level, counties and cities can establish some of their own rules for local elections, candidates for local office. So we have these tiered levels of control over the electoral process at the federal, state, and municipal level. At the state and municipal level, this doesn't mean that the federal government has no control. So the federal government still can determine things to do with state and municipal elections through voting rights legislation and civil rights legislation, or as provided for under the U.S. Constitution. But at least a significant portion of decisions about how to structure state and municipal levels are left up to those localities, to the state government and to the local governments. So I want to introduce some key facts and concepts and then talk a little bit about the landscape for campaign finance today in the United States. Federal election law is created by Congress, and it is, as noted, applied by the Federal Elections Commission. And when there's contestation, debate, or dispute about whether it has been violated or how it should be interpreted, those decisions are made by the U.S. federal courts. So the rules about federal election law are basically an interplay between Congress, the FEC, and the federal courts. The majority of U.S. states also have some of their own regulations governing campaign finance. For instance, the majority, but not all states, will allow contributions by corporations or by labor unions in state and municipal elections. So the Federal Elections Commission in each individual state has authority over what limits are placed on contributions to candidate campaigns, on what the rules are for disclosing the donors, who is giving money to candidates or to policy initiatives or to parties, and any other rules about the ways that campaign money can be used. So I'm going to introduce a couple of other key concepts that you may have occasionally heard about in the media. The first is the term soft money, also sometimes known as non-federal money. And this term broadly refers to money that's not channeled directly to candidates, although it can benefit candidates indirectly. And it refers to contributions that are not under the authority of the FEC, the Federal Elections Commission, or subject to the restrictions of federal elections law, but which can indirectly impact federal, state, and local elections through messaging, also known as electioneering communications, right? So messaging in advertisements, robocalls, other different ways that private money can, or corporate money can strengthen campaigns and parties. It's estimated today that in presidential elections, soft money amounts to hundreds of millions of dollars in the United States. So in other words, we've got the FEC, we've got a set of rules about how money can be used, but we've also got a lot of soft money which isn't subject to those federal, to many of the rules provided for under the Federal Elections Commission. So I'll talk more in a bit about why that is and how that came about, but I want to introduce a few more terms. The second term is dark money, and this refers to political spending that's channeled through nonprofit organizations with designations 501c4, which legally is a social welfare organization, 501c5, which is a labor union, 501c6, which is a trade association. And in each of these instances, these entities are allowed to engage in political spending and not disclose their donors. So dark money refers to ways in which people can channel funding into elections without it being clear who or where it came from, and they can do that by sending it through 501c4, C5, or C6 organizations. And for those not familiar, 501c4, 501c5, 501c6 are all the IRS tax code for certain kinds of nonprofit organizations. So the next term I want to introduce is a PAC, which many of you know stands for Political Action Committee. And a PAC is a political committee organized to spend money and defeat or elect candidates. And generally, PACs are limited to donating just $5,000 to an individual candidate or $15,000 annually to a political party. And PACs in and of themselves, again, are under the jurisdiction of the Federal Elections Commission. They generally have to register, and they have fixed limits on what they're allowed to donate. But there's another category that's more recently emerged in this century, and that's what's called a super PAC. And some of you doubtless heard that term in media reporting, and some may already be familiar. So unlike a simple PAC, a political action committee, a super PAC can take in unlimited contributions. And here's what the Federal Elections Committee says in its definition of a super PAC. And I'm going to read the definition and then help make sense of it. Super PACs are independent, expenditure-only political committees that may receive unlimited contributions from individuals, corporations, labor unions, and other political action committees for the purpose of financing independent expenditures and other independent political activity. The committee will not use those funds to make contributions, whether direct, in-kind, or via coordinated communications to federal candidates or committees. So that's a lot of language. Let's figure out what it means. In essence, a super PAC is an entity which can spend unlimited money. It's not subject to limitations on how much you can donate and where. There are also very few restrictions or rules about super PACs having to disclose where their money is coming from. And what a super PAC can do is spend this unlimited amount of money in politics, in elections, as long as it doesn't directly coordinate with the candidate's campaign, how it's going to do that. So a super PAC, for instance, can put an advertisement on the air about an issue and can attack a candidate or talk about a candidate. And as long as they don't work directly with the candidate's campaign, that's allowed. So super PACs kind of create a loophole around all of the normal Federal Elections Commission rules, which restrict how much money you can give, how much corporations can put into elections, and whether or not they have to disclose where that money is coming from. Super PACs essentially play a very substantial role in the presence of soft money and dark money, and those are overlapping terms, with soft money again referring to any funding that isn't subject to the Federal Elections Commission's regulations, and dark money referring to money that's channeled through labor unions or through social welfare organizations with the designation 501c4, 501c5, or trade associations, 501c6, and can give money without disclosing where it's coming from. So you can spend money, you don't know who the donors are, and there are no limits on spending. So how did we get here? How is this allowed? One thing we should understand that in the 20th century, the federal government took increasing steps to restrict corporate control or influence in elections. And this process, these restrictions, are often referred to as campaign finance reform. And they continue to do so into the early part of the 21st century, notably with a law that was enacted passed in 2002, and I believe enacted in 2003, called the Bipartisan Campaign Reform Act. So, for instance, the Bipartisan Campaign Reform Act, or BCRA, among other things, prohibited corporations or unions from using their treasury to fund what's known as electioneering communications, also known as broadcast advertisements mentioning candidates. And it didn't say they couldn't do that at all, but it said within 30 days of a primary election or 60 days of an election, that corporations couldn't pour money into buying ads about candidates. Right? So this was the BCRA, and it was passed by both parties, as noted, in 2002. And so the question we can ask is, if we have this law, how did we then wind up with super PACs, which clearly allow corporations to pour a ton of money into broadcast advertising? So the answer comes down to a Supreme Court case, which was argued in 2009 and decided in 2010. The name of the case is Citizens United versus Federal Election Commission. And the case was decided under the leadership of Chief Justice John Roberts, who continues to be the Chief Justice of the Supreme Court. And it overturned portions of the BCRA, really overturned pretty much all of it, and a number of 20th century campaign finance rules, some of which went back at that point for about 100 years or more. So 20th century law dealing with campaign finance had been concerned and had expressed that the government has an interest in restricting corporate spending in order to prevent corruption in elections. The plaintiffs in the Citizens United case were a politically conservative nonprofit organization. And they argued that corporations should, like individual people, be understood as legal persons. So corporations should have the same right as people, as persons, even though a corporation is not, in most of our experience, a person. A person usually has to have a physical body in the way that we think of it. So the Citizens United plaintiffs argued that corporations are persons, and that since they are persons, they should be protected by the First Amendment to the Constitution, and they should have a protected right to engage in political speech. They then argued that if you restrict a corporation from engaging in unlimited political spending, this would restrict their ability to engage in political speech, like buying an advertisement, and therefore would violate the First Amendment. So the court first had to decide, are corporations people and therefore protected by the First Amendment? And do campaign finance rules, which restrict how much corporations can spend, violate their right to free speech as persons? So the Supreme Court voted 5-4 that indeed there was not a significant risk of corruption by allowing unlimited corporate spending, as long as corporations did not directly coordinate with candidates. So if corporations acted independently of a candidate and bought advertisements, but without talking, for instance, to the candidate or to their campaign manager, then as far as the court was concerned, that would not create corruption. They also decided that corporations should have First Amendment protection. So the rights that individuals have to political speech should be protected for organizations like corporations as well. So corporations are people, and if we restrict their ability to contribute unlimited political money into elections, then that is a restriction on their First Amendment right to free speech. This was a very close call. It was a 5-4 decision, and basically the conservative wing of the court voted for it, which at the time was Chief Justice Robert, as well as Justice Kennedy, Justice Alito, Justice Thomas, and the late Justice Scalia. And there was a dissent, and the opposition came from Justices Ginsburg, Sotomayor, Stevens, and Breyer. So in essence, Citizens United, which was ultimately argued in 2009 and decided in 2010, said corporations are people and they have a right to free speech, and therefore we should not place restrictions on how much they can spend on advertising during elections. So the only restriction the court upheld is just that they should not directly coordinate with a candidate's campaign while engaging in their unlimited free speech. Daniel I. Weiner, who's with the Brennan Center for Justice, published a report after this ruling and described the impact of the case by saying that now a very small group wields, quote, more power than at any time since Watergate, while many of the rest seem to be disengaging from politics. He elaborated, stating, this is perhaps the most troubling result of Citizens United. In a time of historic wealth inequality, the decision has helped reinforce the growing sense that our democracy primarily serves the interests of the wealthy few, and that democratic participation for the vast majority of citizens is of relatively little value. Now, I want to just revisit again the definition the SEC provided just to make more sense of it, of what a super PAC is. So the SEC specified that a super PAC can receive unlimited contributions for the purposes of financing independent expenditures and other independent political activity. So super PACs as a designation basically grew out of the Citizens United decision, or at least expanded under it. And the super PAC designation reinforces what the Citizens United decision says, which as long as you don't directly coordinate with the candidate, corporations can spend as much money as they want, and in most cases are able to do so anonymously. So I want to just acknowledge a couple things. First, we can't underestimate the impact of advertising and, in some cases, millions or hundreds of millions of dollars at the federal level spent in elections, on elections. So one of the things we know is that the general public in the United States often doesn't have a lot of independent information about candidates or about policy initiatives. Most voters are relying in substantial part on advertising to make sense of what's going on. So if you are allowed to pour just enormous amounts of money into election, your impact can be very significant. And this has led to the charge that the Citizens United case has enabled corporations to basically buy elections or buy candidate wins in some cases, as well as to substantially impact or buy decisions in voter initiatives, policy initiatives that are on the ballot at any given time. So it's not just governing candidates. Now, for those of you who attended our session last month on voting rights, you may recall that we discussed a case called Shelby County versus Holder, which the Supreme Court decided in 2013. And the Shelby County decision substantially removed some of the protections of the Voting Rights Act of 1965. So it made it more likely that voter suppression of racially marginalized voters would occur. And that decision, again, was in 2013. The Citizens United decision went into effect in 2010. So these two Supreme Court decisions in tandem are part of the landscape in which we can understand how elections has changed. And particularly both of these decisions together were impactful in the 2016 presidential election. So one of the reasons that there are hot debates right now over voter suppression, ultimately goes back to the Supreme Court decision in Shelby County versus Holder. And one of the reasons that there's a lot of conversation and urgency about the independence of elections, about the lack of democratic process, goes back to this Citizens United decision, which allows a very wealthy segment of the United States to have a very disproportionate impact on the electoral process. So where are we now? What can be done about this? One challenge we face, and it's not a small one if we're thinking about what would it mean to advance or reestablish campaign finance reform in the United States, is that we continue to have a Supreme Court and a number of federal court judges who are based on their track records, very unlikely to want to go against or to undo the Citizens United versus FEC decision. So in other words, I think that if a challenge to the Citizens United decision went before the Supreme Court today, it would not be successful. And I can say more if there are questions about why that would be. The second thing to note is that Citizens United was not based on an interpretation of federal statutory law, meaning it wasn't about what Congress was doing, or it was in the sense that it was challenging the Bipartisan Campaign Reform Act. But the basis for the decision in Citizens United was the First Amendment to the Constitution. And remember that the federal courts in the United States, if you attended or listened to our prior episode on the federal courts, are the ultimate decision-making body in determining the meaning of the U.S. Constitution. The only way that Congress or the state can ever override a federal court decision about the Constitution is to amend the Constitution, which is quite difficult to do, since it requires a substantial supermajority of state legislatures to go through. So when the Supreme Court, which is the highest federal court in the land, determines that something is constitutional, required under the Constitution, Congress can't overrule them. Congress can't just pass a federal law that reestablishes the Bipartisan Campaign Reform Act or violates what the court decided in Citizens United. So what else can we do? Well, one thing we can do is exactly what y'all committed to do today, which is to get civics education and to use that hopefully as the foundation for civic participation. So one of the greatest things that has proven over time to be influential in shifting the positions of the court or in shifting the behaviors of election monitoring or election or bodies with electoral authority has been strong public pressure. And for that to work, people have to understand what campaign finance is about, at least the basics, which is all we've just begun to cover today, and to understand why it matters, why democracy is threatened when there's not protections against corruption in the electoral process. Once we understand what's going on, there are a number of things that are in our power. One is to start to put more safeguards in at the state level. So there are things that states can still do to require disclosure of donors, to safeguard electoral processes, and also one of the biggest ones, which very few states do, which is to commit to publicly funded civics education. One of the best ways to inoculate people against deceptive or incomplete advertising is to educate people so that they have independent ways to understand what's going on and to research particular issues and aren't so susceptible to advertising from any party or from any PAC or entity. So public civics education is one of the best ways to work around this. Now, I have a book recommendation to share today, and the title is Buying the Vote, A History of Campaign Finance Reform. And I think it's a good starter text for those who are just wanting to make sense of the ways that election campaign finance reform has played out over time. So again, the title is Buying the Vote, A History of Campaign Finance Reform, and the author is Robert E. Much. And we don't usually share film recommendations in the Civics Project, but I'm going to today, and to mention a film called Dark Money, which was directed by Kimberly Reed and released by Big Sky Film Productions. One caveat I'll say about the film is that I think there were some things that would have been good to cover that they did not engage. For instance, the film kind of only looked at the white electorate and white politicians while not acknowledging that. And it focused on the state of Montana, which does have an indigenous population. So my film recommendation is made with that caveat. But the film Dark Money is a great way to look at, Dark Money is the title again, and the film Dark Money is a great way to explore at the state level how are donations which are not disclosed allowing corporations to tinker with or mess with elections at the state level. And it's a pretty powerful documentary and was made by folks in that state, Montana. So Dark Money, directed by Kimberly Reed. There are a few questions in the chat. I'm going to see if I can engage some of them in Zoom. If a campaign announces their campaigning intent publicly, and then a super PAC spends to support those publicly acknowledged goals, how is that not coordination? Well, that's a great question. But I think that the Citizens United Supreme Court and the Citizens United plaintiffs would say, if the campaign is not talking to the super PAC, then they're not coordinating. So as long as there's no proof or evidence that they have directly worked together, then basically the idea is that the super PAC is just independently engaging in speech in support of the candidate. What possible rationale could there be for considering corporations persons? That's the second question. Thank you, Eric and Sharon, for that one. So what possible rationale could there be for considering corporations persons? Well, if you were really interested in seeing how the Citizens United plaintiffs argued it, you can certainly find the judicial opinion online, for instance, through SCOTUS, the Supreme Court of the United States' official website. And you can also read a number of analyses through organizations like the Brennan Center for Justice. But my most quick and dirty answer, and this is not by any means comprehensive, would be that the rationale is corporations are made up of persons and they should have rights and should be considered part of the citizenry. So while a corporation can't individually vote, the Citizens United plaintiffs argued that a corporation can still speak and does speak, just like individuals do, and therefore should have the same rights as other persons. And I don't necessarily agree. It's pretty evident that I don't agree with that rationale, but that would be how it was articulated. And if you wanted it to make more sense to you, I would have the same reaction. I would say it's never felt right to me either. So I can appreciate those that are criticizing it. So last but not least, for today's recording, I want to do our civics trivia for the week. And this was prepared by one of our interns, Sophie. So thanks, Sophie. And I'm going to pull up some slides for those who are with us in the chat, for those who are with us in Zoom today. And then for our listening audience, we'll still be reading out all of the questions. So first question, what is the FEC responsible for specifically? Oops, sorry, wrong one. And answer choice A, providing all political candidates tax documents related to their campaign spending, helping each candidate budget their campaign donations to ensure there's enough money to last the entire campaign. That's B. C, enforcing the laws that govern the U.S. campaign finance system for campaigns for president or Congress. Or D, all of the above. Feel free to take a second to think about that one. And the correct answer is C, enforcing the laws that govern the U.S. campaign finance system for campaigns for president or for Congress. Second question, per FEC guidelines, who can contribute money to a candidate running for office? A, federal government contractors. B, foreign nationals. C, professional organizations. D, Indian or indigenous tribes. Or E, none of the above. The correct answer on this one is tribes can. So native tribes can contribute money to a candidate running for office, but under FEC guidelines, which are not being applied to super PACs, mind you, professional organizations, foreign nationals, and federal government contractors cannot contribute to a candidate. 3, which does not fall under the definition of a candidate's personal funds? So candidates are allowed to spend a certain amount of money of their personal funds in a campaign. So which of these is not included? Wins from lottery tickets or gambling or games of chance, that's A. Income received from trusts after the candidacy is established. C, income from trusts established by bequests even after the candidacy is begun. D, all of the above. Or E, none of the above. And the answer is income from trusts cannot be used as part of a candidate's personal funds. And I'm putting some more learning resources up on slides for our live audience to learn more about any of these 3 issues. And I will also put them into the chat. So for both our live and listening audience, I want to invite you to join us next week for our session on children's rights and child welfare, which is going to feature Professor Kim Hai Pearson, and to join us on May 9th for our session on family and medical leave, law and policy. On our session on May 16th, we'll cover Veterans Affairs. On May 23rd, we'll be featuring a special guest, Deborah Dorfman, who's considered among the foremost disability rights attorneys in the United States, and she'll be here to talk with us about disability rights. And I'm very excited to say that on May 30th, we will be interviewing Janine Abrams McLean, the Vice President of the organization Fair Count, which she runs along with her sister, whose name some of you may know, Stacey Abrams. So Janine Abrams McLean, we're really excited to host her from Fair Count on May 30th. In addition, our monthly film screenings for this month, we will have one this Wednesday. The Great White Hoax, Donald Trump and the race and class and the politics of race and class in the United States. We'll be having a virtual watch party and discussion of the Great White Hoax. If you are registering for that one, there's information in the registration confirmation on how to access the film, so please read that. And then for May, on May 26th, we will be watching United States of Conspiracy. So I hope some of you will turn out for that one. It should be an important one. Okay, so I want to thank everybody who's been both here live or listening in. Those of you in the Zoom, please feel free to stay to share questions or comments after. And to our listening audience, thank you so much for tuning into the Civics Project.